This podcast is proudly sponsored by Healthcare Administrative Partners, serving the revenue cycle management needs of radiology practices since 1995. Visit us online at hapusa.com.
Hello, welcome to another episode of A Firing Line. This is Saurabh Jha, your host, and today I'm at the CATO Institute in Washington, D.C. And joining me today is a senior scholar at the CATO Institute, Walter Olson, who is an expert in malpractice reform and has written several books, including the one we're going to discuss today, The Litigation Explosion. Welcome, Mr. Olson.
Thank you for having me on.
So this book that you wrote, which I would really urge the readers to buy and read, is largely about how America became so litigious. Now, somebody like myself who grew up in the UK watching dramas and watching LA Law or movies with lawyers having great impact, we view the American legal system with both a little bit of admiration, but also intrigue. And we think that Americans, they no longer resolve their differences by the gun, but they do so by the law. And so America seems to be famously very litigious. And in this book, you say that is not the case. You make the case that there's nothing culturally with the United States that makes Americans litigious. Rather, it's a system that has come about by many means. Can you explain that a little bit?
Yeah. You can separate the history into three phases, which is through much of American history, to backtrack slightly from the thesis you just mentioned, America was known as more litigious than many other countries. And there were many reasons for that, including the fact that you had a large continent of unsettled land claims, for example. So there was sometimes more to sue about. And then the process starting in really the mid-20th century and continuing for some decades, in which the United States suddenly galloped in front, becoming much more known for litigation among professionals in the business community than other countries. And then most recently, a period that you might describe as catch-up, in which some of the American syndrome, if you want to call it that, has been spreading to some other countries, in which countries like the United Kingdom have become more litigious and more Americanized, although still typically far behind where the U.S. is. So my book is about that middle period, from the 1950s, which is looked back to in America as an era in which litigation was much less important, much less pervasive. They changed the rules, and of course you had the same national population, but one of the great themes of the book is that people respond to incentives, and that the same basic group of people, if you dangle before them a system in which it is procedurally easier to sue, in which it's easier to hook up with a lawyer who wants to do these things with you. The dance card is made very easy to fill out, and in which damages to attract you possibly to sue are higher and come in more categories, then people will respond to these incentives. People will more often make the choice to pick up the phone and call the lawyer, or to pursue a dicey or uncertain claim that they might have dropped in an earlier generation.
And it seems that one of the turning points, inflection points, and clearly it was an inflection point, was the permission of lawyers to advertise their services. Can you tell us about that?
This came in a famous U.S. Supreme Court decision applying our First Amendment, treating it as a free speech issue of commercial speech, which is applied to many other areas of advertising as well. But in this case, they said that lawyers, like toothpaste manufacturers, are protected by the right to advertise. And I go into that decision because it was not a complete bolt from the blue. By that point, not only had the public mind been somewhat prepared, but also the judicial mind had been prepared for the idea that there would not be anything terribly disastrous if lawyers were allowed to stir up litigation more. That was always the objection to letting lawyers advertise and pursue business, was what Lincoln and many others used to call the stirring up of litigation. It was considered self-evidently a bad thing back in Abraham Lincoln's time, but by 1970 or so, the law schools had changed, the tone in elite levels of the legal profession had changed, kind of turning the earlier conventional wisdom on its head, saying, well, what is, after all, is so bad if they stir up litigation? The more litigation they stir up, the more people will have a chance to get justice. You're not against justice, are you? I mean, the arguments began to write themselves. That yes, there will be more litigation, but by that point, by 1970 or so, they were beginning to see that as a good thing that could be welcomed.
Right, and that's sort of kind of an academic sleight of hand that happened, where the belief was that legal services are good in their own right, and by advertising, you're exposing more people to this good. And in some ways, it kind of very much follows the medical path, or at least the pharmaceutical company path, which is around the same time that Big Pharma could advertise as well. And I find it quite ironic these days that people are very much opposed to direct-to-consumer advertising of pharma, but seem not to be as perturbed by direct-to-consumer advertising of lawyers. And one seems to have owned this moral good, and the other one seems to be in some sort of moral equipoise. And how have the legal scholars made it seem as if access to lawsuits is good in its own right?
Well, they would speak of grand phrases like access to justice or access to the courts. You could hardly be against them when they phrase them that way. And they point out, which is undoubtedly true in some circumstances, that if you can hear from many lawyers, that you can get them to compete with each other for fees, or you can find ones that are more expert in your area. But the questions that were not asked are some of the same questions that come up in the pharmaceutical area, and I'm fascinated by the parallel there. And the way I describe it, I have, of course, a different way of describing it, is that for both pharmaceuticals and legal services, people want a lot of things that are not necessarily good for them, or not necessarily good for the wider welfare of their families and communities. And allowing advertising will sometimes quite efficiently let people hook up with things that are not good for them, things that they can wield either to feel momentarily better in a physical way, or to express their anger or perhaps their covetousness in ways that even they may regret by the end of the cycle.
And guarding this, and I found this very intriguing when I was reading your book, guarding this were very strong ethical standards that the lawyers had. Oh,
there used to be long treatises of legal ethics about all the different ways in which lawyers must not chase business. They were not supposed to join groups of divorced parents, for example, because it would put them in the way of people who might want to revive custody claims and things. They were not supposed to participate in news articles of some sorts. There's a story about how when the very popular genre of TV show came along, the People's Court, or retired judge dispenses justice, it was very hard to find the expert person to serve as the judge, because by and large anyone who had a bar membership, at least back in some states at some times, was forbidden to go on because it might promote their legal services, even to play a judge on TV.
And there's actually, as you mentioned, an actual ethical canon number 28, which is against stirring up litigation.
And that one, of course, stood in the way of what a lot of them wanted to do. And the various ethical canons have been reinterpreted or simply fall under disuse often. Now in America, it's yes, there is still some enforcement of some very blatant direct personal showing up in emergency rooms, for example. But short of that, the deregulation has been more or less complete. One of the news stories that made it into NPR about a week ago was that geofencing, the technical technique by which cell phone ads can be beamed only to those in certain places, like within a store, for example, or within a stadium, is now being used for hospital emergency rooms, so that the idea is that ads for personal injury lawyers can be beamed only to those who are sitting in the waiting room, wondering whether their dear ones will make it out.
Right. So I'm going to ask this because I find it quite unbelievable, but you've written it. So this legal ethicist Monroe Friedman could write provocatively, but in all seriousness, of a professional responsibility to chase ambulances. So firstly, this ambulance chasing lawyers is not urban myth.
Oh, by no means, no. There are whole colorful books that are written about the there's so much money to be made in chasing certain types of business, particularly like asbestos exposure, the genuinely deadly industrial exposure, that the huge amounts of money and time and effort. For example, if you look at what are the most expensive words to advertise on in Google search advertising, ones connected with asbestos illness may get, $50 a click, $75 a click? And obviously, if you are advertising Hollywood movies or something, there is no way that you would pay so much for a click. So they basically rule the roost as far as having the most, the greatest penetration for wherever they want to be on the web.
So just to summarize so far, there was a Supreme Court decision that was pending, that was kind of inevitable, one might even say, that allowed lawyers to advertise as an expression of the First Amendment, or as a logical corollary to the First Amendment, which overnight literally led to an explosion in litigation, particularly personal injury litigation.
Well, it certainly led to a great expansion of advertising. The explosion in litigation, as I argue in the book, was already underway, but this helped it along tremendously.
So I'm just going to play the devil's advocate, the devil's lawyer. One might argue that this was an unmet demand, and that the only way you could actually have fairness in a capitalist society with few regulations is to have very strong courts and enforcements of contracts, or So, for instance, when you had the Union Carbide tragedy in Bhopal, India, sure, toasters were flying into Bhopal along with Mother Teresa, right? But some would argue that that's not a bad thing. That's a good thing.
Well, up to a point, you could even get me to agree with some of that, in that if people who genuinely have mature claims they would like to purchase cannot find out about the right to do so or the chance to do so, you will have genuine problems. But let me turn to a couple of the reasons why, over the centuries, generally not just Anglo-American law, but law in other countries, converged on an ethical norm of not promoting litigation. And one of them is the maxim, I think, acknowledged by most good lawyers, that if everyone asserted all of their legal rights, society would be at an end. We would be spending all of our time and resources just suing over the plausible, the colorable claims, because there are so many of them, because there are so many things that people have done, have wronged our family in the past, that could be crying out for remedy. And part of the answer is that the law turned the stirring of litigation into an ethical violation. And you could see it in areas like people promoting divorce of people who might not have gotten divorced, or people promoting family fights or property fights. But you can also see it in the various other ways in which the law discouraged speculative or unnecessary litigation. And of course, the biggest reason, which we can get to later or now, is through loser pays or costs follow the event rule, which differentially discourages, of course, cases that are more likely to lose. But there were many other ways as well. The general machinery of procedure for litigation was not set up to make it easy. It was set up to let those salmon make it over the hurdles that were particularly motivated to, that felt sure that they wanted to sue and had something real to sue about. That was the practical effect, if not always the purpose, of the series of hurdles, other than advertising restrictions, that kept people from being in court.
And coming to that, the loser pay all doctrine, the other side of that is the contingency fees, and you put that as quite high up as one of the reasons why litigation has become so easy. Though it's hard to actually understand that at first glance, because contingency fees means no win, no fee. So it seems quite fair, actually, in some ways, doesn't it?
Well, not necessarily, because it also means no skin in the game. It means that the allurement to someone suing is there is no downside even if you turn out to be wrong in your accusations. Now, does that match up with society's interest or with the interest of justice? I'm not so sure. I think that perhaps there should be a downside to particularly accusing people of disgraceful things. It's one thing to say my tax bill is wrong. It's another thing to say someone else deserves to be held up for public blame for having injured me. And so the problem that legal systems historically saw with the contingency fee, however, is not that it made things too easy for the plaintiff, but that it changed and warped the incentives of the attorney in between. And for this, you can argue by analogy. You can say, why is it that we get very uneasy at the idea that someone in the government might keep a quarter of the fines that they levy against us, or so a traffic policeman, for example, might keep a share of the tickets that they write against us? Well, we quickly realized that the reason is that we want them to be fair and objective, even if it means not writing the ticket, or even if it means not prosecuting us, and that getting paid per scalp, getting paid an especially large bonus if they convince the judge or jury to hit us with an especially large fine, gives them incentives to overplay their hand, to perhaps conceal evidence that might be in our favor, to remember their own eyewitness role of seeing us speeding in such a way as to box us in with the most damaging possible memories. And this is indeed exactly what is observed of lawyers who have moved on to contingency fee. And by this point, America has experimented with all sorts of varieties of it. We have contingency fees for defense lawyers getting people off. We have contingency fees, sometimes horrible as it sounds, for expert witnesses saying, if you convince someone that this was not the standard of care, you get an extra bonus. Now, each time you extend this percentage fee for results into another area, you get someone whose testimony or whose participation in the system is not quite as objective as it was before. And so American is known for cutthroat lawyering. And it's not as if cutthroat lawyering is unknown anywhere else, but America seems to have developed more of it. And when, for example, contingency fees made their way into business versus business commercial practice, and it was argued that proof that they've violated the contract and you will get 20% of the damages. Well, commercial litigation in places like California heated up and became more LA law-like. And this is part of the overall American syndrome. You can abstract away from just the personal injury cases that are best known. America winds up with this type of lawyering more often because we have given them a freer hand to set up incentives that lead there.
And one could argue that contingency fees, the percentage of the win, is what actually took which was actually what made lawyers take on cases of cerebral palsy, because the payouts were so dramatic. And so even if you didn't have a mistake, and they've done studies that have shown that despite very aggressive cesarean sectioning and very aggressive fetal monitoring, the rate of cerebral palsy has not shifted. So it was never really about those hypoxic moments. during birth. But now that you've got this dramatic outcome and you've got a process that appears to be, a fallible process that appears to have a mistake, all of a sudden your payouts are going to be all over the place.
The payouts attracted a great deal of high-end legal talent into areas like infant brain damage, as you say, in the teeth of the more cautious epidemiological approach, which was trying to figure out whether or not it was actually obstetricians causing the injury, and which in retrospect suggests that a lot of money was recovered on cases where it was not the fault of the OBGYN. But that is part and parcel of the contingency fee system, is that lawyers become effectively part owners of claims, and they lose interest. There are, I'm told, quite a few poorly practicing podiatrists in America, but they hardly get sued at all because the damage figures for foot damage are just not high enough to interest lawyers in going after some of the malpractice in that area. On the other hand, they are so high in the case of infants, they are so high in the case of a few, like failure to diagnose certain types of cancer, that they flood into those areas, and you get, as someone once put it, 10 out of every 3 meritorious cases get sued. And
podiatrists don't have a terribly deep pocket.
Well, that may be another fact, but the fact is that some areas are known for, in the case of psychiatrists, for example, there's a small number of exposures, such as suicides, in which there's large dollar amount and dramatic possibility, at least in some states, that are favorable to the plaintiffs. Most of the things that psychiatrists get sued for, they don't get sued for, because the damages are not proven out as far as jury's willingness to award sorts of things. So you wind up with lawyers following the money and trying to stake out presences, even if there are 4 or 5 other lawyers suing over neonatal injury. Beat that 5th one, because there is just so much more money in that than in pursuing the more humdrum and low damage problems that the medical profession may create.
I'm just going to stick to this contingency and draw an analogy, which actually you drew in your book, which is that, and it's not a strict analogy, but it's a good to talk about it in the abstract. A lot of people say doctors should be paid not for the process, but for the outcome. And so if you cure somebody, you should get paid more, and if you don't, you shouldn't. And if it really works, you've really made a difference, and you get great satisfaction, you should pay more. But I'm going to put that aside, but tell me, what do you think is the problem if doctors were paid contingency fees?
I think there are a lot of fascinating parallels here, and it frightened me once I realized that there were people proposing that doctors be paid by success. One of the problems in both areas is that the proffers of evidence by which you know whether or not something is going well often come from the same professionals whose money is on the line. And so someone who is in fact in decline can be brought to that all-important 365-day or wherever the payoff occurs by the administration of feel-good pills to prop them up over the line, so to speak. And then you find out after the payout has been made that they were not in such good shape. Likewise, what would happen to autopsies? What would happen to reports of causes of death if doctors' compensation hinged much more broadly on the determination of what had killed a patient? Well, they would become less trustworthy. And unfortunately, forensics, both civil and criminal, is an area in which the incentives of the American legal system have done a lot of ill. I'm sure have done some good, but one of the books that we recently had an event for here at the CATO Institute was over criminal prosecutions in Mississippi and Louisiana, in which prosecutors all over those 2 states relied on a couple of forensic experts who were just magicians. They were able to take seemingly spoiled and washed away evidence and come up with a reasonable certainty that it pointed to the bite marks or the strangulation marks or whatever of exactly that person who the police had already targeted as their preferred defendant. Now, years, even decades later, sometimes confessions to these crimes by other criminals or DNA tests or various other long delayed evidence revealed that the forensic evidence had been, in fact, completely wrong, and that the person had been nowhere near the scene of the crime, by which point they might have spent 10 or 20 years in prison. And you should have believed their alibi in the first place, but what are you going to believe? A pathologist or a forensicist in a white smock, or just someone at a nightclub who said that they were with the defendant that night? Well, so the horrors that have been uncovered in forensic evidence have a great deal to do with the fact that the compensation of the testifying experts had to do with the satisfaction they were able to give to the prosecutors, rather than to some better and more objective measure of whether their testimony was valid.
And so you could have, if you pay doctors for contingency, you could have doctors making millions on placebo.
Yes, especially on placebo or on things that are in fact habit-forming, but not prescribed as such. The many different ways in which people can get things that please them in the short run.
So now I'm going to move on to my own profession, medicine, and particularly radiology. If you speak to many physicians, actually, particularly those practicing, and the first thing they'll say to you is, we need tort reform. It seems to be a kind of almost universal thing across physicians. The American Medical Association has asked for it, and it was conspicuous by its absence in the Affordable Care Act, possibly due to lobbying by the lawyers. So there are two arguments. The empirical evidence shows, some studies have shown that states that have enacted various measures of tort reform have reduced the overall expenditure, healthcare expenditure, and others have not shown dramatic reductions. Nevertheless, I think it's generally accepted that defensive medicine is something that's very much prevalent, and one of the reasons why radiology is so used. I mean, my own professional existence comes from defensive medicine, or comes from medicine that a level of uncertainty people don't like. So I have a couple of questions for you. The first is, do you think that tort reform will, what good will it do in terms of healthcare expenditure? Would it reduce defensive medicine? Would it reduce healthcare expenditure? Or, and if so, why are studies not really actually showing this to the extent that we believe it to occur?
Okay, well, tort reform, although stymied at the federal level, has very much gone forward at the state-by-state level, and that has had a major impact because, of course, most tort suits are under state law in state courts. And so when Texas, Michigan, Ohio, many other large states have enacted substantial tort reform, the effects have been very real, as far as you can sometimes measure in the data from the insurance industry, that smaller flows are getting through and lesser amounts are being spent on legal defense. And in general, it is working the intended way there. Now, it can be extremely difficult to tease out which tort reforms. That Texas and many other states tend to enact a suite of 10, 15 different things, everything from joint and several liability to the role of scientific evidence to categories of damages. And studies that have attempted to pick on one of these and determine does it make a big difference are often quite spotty. We know that the overall suite seems to make a difference. It is not as clear that limitations on non-economic damages, for example, to take one that is absolutely beloved of tort reformers, and it certainly has had some impact. It is harder to find whether that has made a difference. And as you say, the things that are not encompassed in reform can be extraordinarily important ones in terms of driving costs. For example, I think you have probably seen, and I've seen, ones indicating data indicating that some of the highest cost hospitals with highest rates of use of things are in some states that have reformed law, and thus indicating that there are some reasons for overtesting other than necessarily the legal climate. An example that I use regularly is that if you compare the hotness of the malpractice environment as far as the likelihood of being sued and paying and the insurance rates and so forth between a place like the Bronx or other boroughs of New York City and, let's say, rural areas an hour outside of Syracuse and Utica and Buffalo, New York, you find such a tremendous difference you would think you were in different countries. And yet, of course, the joke is that they are both part of the state of New York. So elements of the system, and in the state of New York, by the way, one of the things that you would find is that judges in the Bronx are elected with campaign contributions from the plaintiffs' lawyers who practice before them, and judges in near the St. Lawrence River, 4 hours drive away, are not necessarily on the bench with any such contributions. And that might make a difference in why the lawyers get away with so much in New York City. Again, how do you address that with tort reform? New York happens to be a state that hasn't even tried, but so the legal system is many things other than the state of the law. That having been said, those changes notoriously turned Texas, turned quite a few other states from malpractice suit hotspots to malpractice suit non-hotspots, to the point where in Texas it got quite notorious. The lawyers were going around basically complaining the way farmers do during a drought, saying, we're turning to patent suits. Texas has become a hotspot for patent suits because we found we couldn't make money against the doctors, but we can make money against the high-tech companies. And people laughed, and yet there actually was some redistribution of resources, according to the lawyers involved, between fields as seemingly disparate as that, because the doctors were so hard to sue after the Texas legislature had returned for the third or fourth round of malpractice reform. So where does it have its impact? Well, you can see some of its impact on the doctors' surveys of good states to practice in. You can see some of the impacts in the insurance rates that they pay. And there used to be, these are now quite old, but there used to be cliffs of insurance rates, for example, between Chicago and the Indiana communities that are really a rather short drive from Chicago, but between Indiana's different malpractice law and its tremendously different culture on which it prides itself. We are not Chicago. In no way are we like Chicago, says Indiana to itself. And so you would find an 8-to-1 cliff if you only relocated your practice out of Chicago. Now, Chicago people will not drive to Indiana for care by and large, so you were giving up a great deal at the same time. But so you had lots of these natural experiments in which the states with the lowest malpractice insurance rates, by and large, were also states with very low rates comparatively of insurance. Malpractice in particular, as it has been reformed in a majority of states, but there are 10 or 15 states that have not significantly reformed, it has tended to become something of a regional problem in America, in which New York, Pennsylvania, northeastern states continue to have quite substantial amounts. Much of the rest of the country has addressed the problem and does not feel as much of a pinch.
So getting to the actual goodness of tort, there was a famous decision by Supreme Court, or wasn't Supreme Court, but Judge by the surname of Hand and his Hand formula in a canal barge accident, in which he said that the probability of actually or the probability of having a damage, and he linked that to the the cost of the damage and also how easy it was to actually avoid the damage. So the avoidability of the damage or avoidability of the injury was a measure of whether or not the plaintiff should prevail. And that became known as the Hand formula. And so a lot of legal scholars, such as Guido Calabrese, Tom Baker, say that people don't naturally think about these avoidability situations. And without the tort mechanism kind of, revs up people's thinking so that they think about the ways that they can actually prevent an injury. And one of the most dramatic examples of that is actually in medicine, in anesthetics, where there was a lot of lawsuits because of equipment being clunky. And they sat down and they said, well, what are we doing wrong? And they figured it out, and anesthetics became safer, anesthetizing became safer. Their malpractice premiums failed. So a lot of legal scholars use that as an example to say that tort has some good. What do you think of that?
Well, first, I would never deny that tort does do some good, else we would join New Zealand in moving to a no-fault system in which government compensation were substituted across the board. If you look at traffic law, for example, there is something good about the fact that people with terrible accident records have an incentive to get off the road, namely prohibitive insurance rates. But from a few of the easier examples and easier cases like that, I'm afraid that the law schools got a bit infatuated with the precision and universality with which they could begin dispensing incentives. From the idea that drunk drivers are probably responsible for their accidents, which I fully endorse in most cases, even though occasionally you will miss one in which it was the sober person who caused the accident. They move to ideas of, well, we can identify the least cost avoiders. Well, no, actually, that's a much harder problem in a complex situation like that of modern medical care, to know for sure whether or not a tweak on the pharmaceutical company side or a tweak on the emergency services side, or where exactly is the least cost, or is it perhaps the person themselves in many cases who could have been taking better care of their health? Well, in practice, the law tended to answer these in what it believed to be a generous and wide-spirited way, which is to direct attention away from the poor individual accident victim, who was almost certainly not the cause of their turning into an alcoholic or whatever their underlying health problem was, and toward deep pockets. After all, if an institution has deep pockets, it probably could afford to add specialists charged with fixing particular problems, and also toward multiple joint and several things, since if there are many large institutions, probably attacking them all with a responsibility for liability will, as the Marines used to put it, finish them all off and let God sort them out. Well, the tendency here was toward applying the brush of liability very broadly on the assumption that the large institutions could then sort it out at some point among themselves. And that is where, in moving from the relatively easy cases to the attempt to socialize woe into a new social insurance program, that they found that it worked extraordinarily badly as a social insurance program. And let me mention a couple of the ways in which it works extraordinarily badly, staying with medicine for a moment, although you can extend it to many other areas. First, one of the things one can compare is whether or not high liability countries and localities have more or fewer injuries than other places. And it was frustrating, at least I think it should have been frustrating to them, to realize that America, in area after area, was not getting actual better results out of its system simply by pouring in 10 times the litigation effort. There seemed to still be a lot of the same problems that other countries that did not do it this way were facing. They had not solved these problems either, but the U.S. was not measurably closer to solving them than many countries that did not use the broad end of malpractice litigation as a way of solving them. Then came the problem from the standpoint of social insurance, which is that we would shut down a private insurance company that wasted as much on overhead and paid out with as much delay and whimsicalness of beneficiary as the malpractice system does. Studies suggest that the substantial majority of money that comes in at the one end through premiums is eaten up along the way rather than popping out at the other end as nourishing compensation for actual economic losses, which is what most people buy insurance for. When it does come out, it comes out later than compensation should and more unpredictably than compensation should. And it kind of makes sense because most insurance that we value, most successfully working social insurance programs and most successfully working privately purchased insurance, is meant to pay off without acrimony based on objective triggers of disability or objective triggers of causation, which are absent in the case of most medical malpractice liability, requiring expensive and heartfelt wrangling, heartfelt in the sense that people feel accused by malpractice litigation in a way that they do not by workers' compensation or the various other forms of social insurance that do kind of work as far as successfully redistributing money. So for all of these reasons, America, I think, took a step back and took a closer look as malpractice insurance went through its crises around the 90s, from the 80s on through several cyclical crises, and generally concluded, yes, there is some genuine malpractice. We do not want to prevent the law from addressing those, along with the other means of addressing them, such as professional self-regulation and so forth. But we do not want this to become a routine resort for misadventure, a routine way of going for money when it's very less than clear that the injury was iatrogenic.
And you mentioned lowest cost avoider and why it's seductive and so difficult in a complex system. I'll give you one example. So when I was a resident, one of our radiology attendings showed us a case which was successfully litigated against a radiologist. And in the case, there was a young man who was an intravenous drug abuser and who had a congenital abnormality, coarctation of the aorta, in which his aorta was narrowed, and that was associated with another congenital abnormality, which is that the aortic valve was dysfunctional, was abnormal. He didn't know that, nobody knew that, and he came into the emergency department with fevers, and a chest x-ray was done, and the chest x-ray was clear. And later on he died from infective endocarditis, infection of his valve. So it was a miss. So what exactly was missed was the fact that when you have this narrowing of the aorta, the ribs become a little notchy, irregular. It's a very subtle finding, but it's definitely a finding. So in all of this, in all of the lowest cost avoiding situation, the radiologist was the lowest cost avoider, because all the radiologist had to do was just say there is notching of the ribs, which would have alerted the emergency physician to say, oh, there's coarctation, so this person has an aortic valve that's abnormal, therefore the patient has endocarditis as an explanation of the fever, not viral infection. And but the patient was an intravenous drug abuser. You can't blame the patient, right? I mean, you could argue that despite being an intravenous drug abuser, that does not reduce your, the fault that you missed. So anyway, after that case was shown, I was on call in the emergency department over the weekend, and I started imagining rib notching. And I called it on, 4 different chest x-rays, and the emergency physician phoned me up and said, is there something that I should be aware of? Is there a conference or some sort of meeting of people with coarctation in Philadelphia this weekend that that I don't know? And clearly what had happened was that I internalized that case so much that I felt like I was the lowest cost avoider. But of course, the prevalence of that rib notching is exceedingly rare. And so, you've got this complex system where it appears in hindsight that the lowest cost avoider was the radiologist. But
well, bear in mind that lowest cost avoider, although it became a very important term in the academic literature, it is not typically the term that judges, let alone juries, bring to the determination. There are still supposed to be legal standards. However, one of the great divides is between what I call bright line rules, in which and which can come across in a medical context as cookbook rules, namely, here are things that should never be done. Did the doctor do any of the things that should never be done? Beyond that, you may have sailed into the waters of reasonable differences of political or of professional opinion. Once you encourage the application of cost-benefit tests on a case-by-case basis, as opposed to overall, does it pass the cost-benefit test for us to adopt this new bright-line rule as to what we don't want doctors doing. But once it slides down to an individual case, at that point, you're really in for it, because at that point it behooves the plaintiffs to hire their expert and the defendants to hire their experts, and for voir dire, the process of challenging people off juries because they have ever had any connection with the subject matter being sued over. At this point, the whole paraphernalia of trying to generate uncertainty, if a case does not have as much uncertainty as you would like about it, takes over, and it becomes worth, at least if damages are high, worth doing a lawsuit. And the objective so often in the old law was to keep cases from ever getting to that point by preventing the speculation in uncertain cases, which produces an ever greater proliferation of doubtful micro rules about recognition of ridges or whatever. It is perfectly clear that you will miss some genuine mistakes if you have a more humble approach. That we can say some things about doctors who ought not to be practicing. And my own reading, by the way, of and malpractice law goes back a very, very, very long time in English history. It's not as if it was invented, but my reading is that it was not viewed as a mortal threat to the profession, in part because it operated in practice mostly to eliminate people who, on reflection, judges thought should not be practicing at all, not people who should be practicing. Oh, no, don't quit practice, but you made a mistake in this case. That's one of these finer-grained things in which the Calabrese era of let's get, we're already doing some good, let's do more good by getting the incentives yet more perfect. They thought they could send that message of just because we are hitting you with $1 million damages in these 3 cases doesn't mean we don't want you to be a brain surgeon. You're the best brain surgeon in town. Please don't quit.
Right. And this is where it kind of gets a little ridiculous, because neurosurgeons obviously are one of the most sued specialties. And if malpractice was a kind of a surrogate of how bad a doctor you are, then what is it about neurosurgeons that make them such bad doctors? Clearly, it's not them per se, but it's the risky business that they undertake.
Yeah. And so for most of American public opinion, I think there was this stepping back of, wait a minute, the system is not working the way it was promised it would work. The system is not working the way a sympathetic eye might have hoped that it would work. Let's just dial it back. And as a reformer, I am always rooting for ways of dialing it back that distinguish between the good and the bad cases, between the sheep and the goats, that allow the scientifically well-grounded complaints of causation or injury to get a better hearing than the ones that are just someone's imagination. But that can be hard. And part of what's tragic in this area is that although one can be drawn to things such as what type of expert testimony can be admitted into cases. And in fact, that has been one of the most significant reforms prescribed by our U.S. Supreme Court, was to try to kick out the so-called junk science, the people who were coming in and they were really establishing themselves, saying that strawberry jam caused cancer, and
Right.
we get to sue the preserves maker. This was allowed for a while, and then the courts really did clamp down, and it helped medical defendants, among the many other types of defendants that it helped, to be able to say, no, you can't just come in because you've got some medical degree from some institution sometime in your youth. You have to show that there is a body of scientific support for what you plan to testify. And that helped a lot. And other proposals such as expert medical panels for screening cases that hinge on sophisticated medical testimony have had more mixed results. They are very hard fought by the trial bar, which does not want to lose cases into what it sees as the maw of once you bring in the medical profession to decide what the causality was, they're going to protect their own. I'm not going to say that they're entirely wrong to fear that, but on the other hand, if you make sure that it's inexpert decision makers, then you get a different kind of problem. And I touched briefly on the problems of jury selection, in which it is the very inexpertness sometimes that they are working to reinforce.
And getting to that particular point, I want to now talk about a case that you're well aware of, the case of the paediatrician in the United Kingdom, British pediatric trainee actually, Dr. Bao Garba, who missed sepsis in a 6-year-old child. Actually, it wasn't really just a missed sepsis, it was a delayed diagnosis of sepsis, but was found guilty of manslaughter. And so the case went to criminal court, and she was found guilty of egregious violation. Whereas many physicians, when we looked at what had happened, we said, "Oh, that could really have been us." So I want to get your thoughts on this, because what I see over here, and let's to give you another example. So in India, for instance, when a doctor makes a mistake, the lynch mob comes after them. And this is no urban myth; it happens quite often.
And in China also, I've heard that happens.
And in the UK, although cases of malpractice are rare, they're still far commoner than you would have here. In fact, there was a British elderly surgeon who was also found guilty of manslaughter and actually put in prison, Dr. Selu. So it's not that uncommon. And it's rare to put people in jail for malpractice over here, unless it's something, like opioid abuse. So I wonder, this is speculative, and this, of course, is Britain has a slightly different propensity to litigate, even if it's increasing, even if there's a secular trend towards more litigation. I wonder if you think that in some bizarre way the cash-flushed tort system here protects doctors from manslaughter charges.
Well, I probably won't wind up putting it that way, but you are right that the cultural differences are important. I've heard not only what you say about India and China, I've heard that in Japan, which for various reasons makes litigation difficult, that the yakuza, the mobsters, will go out and threaten to even the score with the doctor that has committed malpractice on you, and the doctor may cough up money. How different this is from certain American lawyers, I'm not still entirely sure. But that there is a bit of a whack-a-mole problem, as we call it, in which you repress one outlet for anger and you find another springing up. That I find much more plausible. And, of course, what is often relied on implicitly in these Western systems is the professional discipline of the colleagues noticing and having means to deny hospital privileges or give bad word of mouth or refuse referrals to in various other ways. And there is, I am sorry to say, a sense that a lot of that, if it ever did work well, has tended to break down. Now, part of that problem may itself be legal, in that among the hundreds of varieties of litigation that America has prescribed for its well-being, one of them is lawsuits by doctors against other doctors for being denied hospital privileges or shunned or bad-mouthed or whatever. And so we may find that some of the also antitrust actions against professional organizations that discourage certain types of practices of their own members. So, I throw that all out there without necessarily knowing where the source of the problems come, but I am not surprised that criminal law gets thrown into the mix. And naturally, I have strong feelings about criminal law at CATO, where libertarians view it as something of a threat to let it get out of control. And of course, the first thing that you think of is mens rea, or guilty mind. Should not charges like manslaughter and murder be excluded from the case for someone who, even if their powers are failing, even if their memory is bad enough that they should not be practicing, they did not intend any harm. We crossed that bridge, so lawyers will say, with ideas of negligent manslaughter in highway accidents, for example, that someone who is whose driving powers are impaired must be guilty, even if the last thing they ever wanted to do was to hit a pedestrian. We can still go after them criminally. But it is a large step, and one that America has been very reluctant to do, to apply that logic to doctors, or for that matter to factory owners, if the negligent factory situation did not involve a breach of law or some sort of bad consciousness.
Thank you, Mr. Olson. Very complex area, and thank you very much for joining us again. And to the readers, I would really recommend that you read The Litigation Explosion, one of the best books on the history and progression of law and the logic of law out there. Also, Walter Olson has a website, I believe, Overlawyered.
Overlawyered.com.
And as doctors are actually worried about overdiagnosis, it's quite ironic that there's also overlawing. The two might be linked. Well, thank you very much, and thanks for listening. We'll be back with another episode of Radiology Fireline. Take care. Bye-bye for now.
Step into the future of medical imaging. Attend the 10th Annual ACR Conference on Quality and Safety, where top quality and data science experts will convene to share the latest tools and insights on how AI can be used to optimize business efficiencies and high-level patient care. Register today at acr.org/quality meeting.
Do you like listening to the Radiology Firing Line? If so, leave a review on Apple Podcasts and tell us how we can do better.